I had to go put on my judge's robe for this. See, I'm going to attempt to convince you why Viva Frei's analysis of Nicholas Sandmann's defamation lawsuit is wrong. My name is Nate Broady, YouTuber and lawyer, and I have a disagreement with another YouTube lawyer. His name is Viva Frei. This guy. Now, here's a quick recap. This video is a reply to Viva's reply to my reply of his original video of the dismissal of the Nicholas Sandmann's defamation lawsuit. First, I want to thank Viva Frei for going through this back and forth and gaining me a lot more subscribers and a lot more traction. Now, originally, I thought our disagreement was over whether the court needed evidence to come to the determination on a motion to dismiss. Specifically, whether evidence was necessary to rule on a motion to dismiss where all the allegations were held to be true. But that wasn't where we disagreed. Viva agreed to this point, and it's not in contention anymore. But we do have a major disagreement. Now, I'm going to focus my argument on his analysis of why the statements that do not specifically name Nicholas Sandmann are not defamatory. Viva makes the claim that the judge came to the conclusion of fact and not law.
All right, first things first. The conclusion that the articles were not about Nicholas Sandmann is not a conclusion in law. It is an assessment of fact, even by the judge's own rationale, and I'll explain why.
Now, Viva will now explain that based on the law the judge applied to this ruling, that the judge is making a determination based on fact and not of law.
In his own judgment, the judge says that in order for an article to be about someone, it doesn't necessarily need to specify them by name. It need only be sufficiently clear to friends, acquaintances, that people know who the person is in that article. So the judge even coming to the conclusion that an article was not about Nicholas Sandmann because it didn't name him is not a conclusion in law, it is a conclusion of fact.
Now, the rationale or rule of law that Viva's talking about can be found on page 7 of the opinion, last paragraph. That states, generally, the plaintiff need not be specifically identified in the defamatory matter itself so long as it was so reasonably understood by the plaintiff's friends and acquaintances familiar with the incident. Now, here is the problem. Viva didn't read the full rule. Next sentence, bottom of page 7 into page 8. But this rule is limited by the principle now memorialized in the restatement. That where defamatory statements are made against an aggregate body of persons, an individual member not specifically impugned or designated cannot maintain an action. That rule that Viva read is limited. So what rule should the court apply in this matter? Continuing on in page 8, for an individual plaintiff to bring a defamation action based on such comments, the Kentucky Supreme Court has instructed that. Now, why are we referencing the Kentucky Supreme Court? Well, this is a defamation claim brought in the state of Kentucky under Kentucky law. And since we're talking about the state of Kentucky and Kentucky law, the ultimate arbiter of what Kentucky law means is the Kentucky Supreme Court. Just like the Supreme Court of the United States is the ultimate arbiter of what the Constitution and what federal law means. The Kentucky Supreme Court is mandatory authority in this particular instance because we're interpreting Kentucky law, and who tells us what Kentucky law is? The Kentucky Supreme Court. The Kentucky Supreme Court has instructed that 1, the statement must be applicable to every member of the class, and if the words used contain no reflection upon any particular individual, no advertisement can make them defamatory. Citation, the Kentucky Supreme Court. So now we have an understanding of the full rule in Kentucky. So the rule that Viva has given us to make his determination is not the entire rule. It is part of a rule, and the part that he's making his analysis on has been horribly limited. The rule that Viva has pointed us to is part of the rule, but it's not the rule that the court is actually applying to these facts in this case. The rule that the court is actually applying is one that comes from the Kentucky Supreme Court, which is mandatory binding authority to this court, and that's the rule that this court is going to use moving forward to determine whether these statements are defamatory or not. So now the court goes into an analysis of the actual statements. So the first statements the court talks about, the ones that it finds not defamatory, are number 1, these statements don't mention Sandmann by name, and there is no identifiable description of him and no picture of Sandmann in the article. Now, these statements the court actually numbers for us. Statement number 1, statement number 2, statement number 3, statement number 8, statement number 13, 15, and 16. There were 33 statements that were alleged to be defamatory, but we're only talking about this group of statements that don't mention Sandmann by name. If we remove the defamatory part and just look at what the statements were talking about or what group the statements were talking about, let's see if there's any way that we can identify Nicholas Sandmann from the group description. Hat-wearing teens. The teens. Teens and other apparent participants. A few people. Those who should listen more closely. And the last statement, which I think is the best, they. Well, the court says that these statements are not actionable because they're not about Sandman. Pointing back to the rule given to us from the Kentucky Supreme Court, specifically that the words used contain no reflection upon any particular individual and no avertment can make them defamatory. So then the court says, okay, here are some other cases in Kentucky where they dismissed the claim because you had similar facts to the facts in this case. First case is Kentucky Fried Chicken of Bowling Green versus Sanders. Now, this is an interesting case because then Colonel said, what? But this is the case. Now, the Kentucky Supreme Court in that case affirmed the dismissal of a defamation complaint where the newspaper published derogatory statements about KFC's gravy because there was, quote, nothing in the present article which identified or made direct reference to the plaintiff's particular restaurant location. But that may not be good enough. Let's talk about the Louisville Times v. Stivers. The court, in that case, held that the plaintiff's defamation claim should have been dismissed because the statements that the Stivers clan had been involved in fistfights and gun battles was toward a group or class and is not actionable as a matter of law. So now we have Kentucky Fried Chicken restaurants, since you didn't name which particular restaurant, not actionable. Now, since we have the Stivers clan, don't know who you're talking about within the Stivers clan, not actionable as a matter of law. Again, these are all controlling, binding precedent that the court has to use to come to a determination. The last case, a case from this particular district, it's O'Brien v. Williamson Daily News. The court again dismissing defamation claims of teachers not identified in the article that mentioned teachers having sex with students because the article referred to no identifiable group member and does not impugn the reputation of any specific member. So now we have 3 cases in which the court says you should dismiss these actions because they name groups and not members, and because they name groups, they should be dismissed. And this is based on the binding authority of the Kentucky Supreme Court. So essentially what's happening is that Viva is just applying the wrong rule. He's applying a rule that the court has limited in a huge way and not applying the correct rule which has been demanded by the mandatory binding authority of this jurisdiction, the Kentucky Supreme Court. Like the statements of groups or classes such as the Stivers clan, Kentucky Fried Chicken restaurants, and teachers, these statements, hat-wearing teens, they, are clearly made against an aggregate body of persons. An individual member not specifically impugned or designated cannot maintain an action. Viva has made this whole argument based on a rule of law that the court isn't even applying because that's not the rule. That rule has been severely narrowed by the rule the court actually uses from the Kentucky Supreme Court. And the Kentucky Supreme Court has made multiple rulings in the past showing that an individual can't bring a defamation claim. They're dismissing it because they're not individually named, they're just naming groups. So I think it's clear. After now understanding the full rule and the rule the court used in this particular case, it is clear the judge made this ruling based on law and not based on fact. As a matter of law, they are bad people is not actionable in the state of Kentucky based on the relevant law and precedent in the state of Kentucky. Actually, it's the Commonwealth of Kentucky, but I say state. So the bottom line is, the statements that do not name Nicholas Sandman cannot support a claim for defamation as a matter of law, just like the case of the Stivers clan, just like the case of the KFC gravy, and just like the case of the teachers. Any evaluation on whether or not his friends or acquaintances could identify Mr. Sandman is irrelevant, because that rule is limited. So just to be clear, this judge's conclusion was a conclusion based in law and not a conclusion based in fact, supported by the binding legal precedent of the Supreme Court of the Commonwealth of Kentucky. If you like videos like this, check out some of my other videos on legal topics. And this is the reason why I believe myself and Viva have a fundamental disagreement. I think Viva just made a simple mistake. It really just comes down to simple than that. Leave your comments below, let me know how you feel, and I'm going to holler at you next time. My name is Nate Broady, YouTube attorney, and I'll check you next time.